We'll turn the recording on now. This is LAWS12066 Land Law, and this is the tutorial in week 7, but we are covering topic 6 because we are still sort of 1 week in arrears, and I will explain next week what we're going to do about that. And there'd be other things like, so okay, we've got 4 minutes to go. I'm not supposed to say anything important, am I? So like everything is coming together, isn't it? The various feature aspects. So you'll get your first assignments back shortly. Second assignment is due tomorrow week. I'm offering some additional time tonight. Not too much additional time, but some additional time if there's any desire for Q&A on the second assessment. I should be in a position, I expect to post up exam information and advice beginning of next week, so that you will be able to give some thought to that. I will be doing a recording for the exam to give you some guidance and suggestions around thinking about the exam. We will also have a revision class toward the end of the term, and plenty of opportunity for people to ask questions about the exam once you get over the second assessment. And still 3 minutes. Can I say important things or not? I don't know. I'll just say that I'll leave this until maybe the Q&A session, talk about assessment generally there. But look, let's focus on maybe what we need to consider tonight in tonight's class. We've sort of only got a couple of minutes to go, so I think that's right. So tonight we're looking at this topic on what's called alienability of property and the rule against perpetuities. Okay, now I just want to get an idea before we start. As I say, we've not got a cast of thousands, but do you feel you're across this material, or would you prefer me to be a little bit more directional tonight? How would you like us to proceed?
Within reason, Michael. Direction's always good.
Right, right. Because I think, you know, like understand that people are involved in assessments and these sorts of things, so that's understandable. And this topic itself, particularly the rule against perpetuities, always presents as a bit challenging for students. There's a few reasons for that, I suppose, and that is that it's a bit different to, I think, some of the other topics we cover in the unit, in the sense that it seems a bit more mathematical, computational, and some students get a bit put off by things of that nature. They say, "Oh, Michael, what are we doing here? We're supposed to be a law student. We're not studying maths degree, right?" So there's that aspect to it. But you know, on the rule against perpetuities aspect, have you had a chance to have a look at the film clip on body heat that I put on the Moodle website? If you haven't, I want to encourage you to have a look at that film clip.
It's a very interesting film clip, to the point that I went and actually got the movie and sat down and watched the entire movie.
All right. Good.
Even though I didn't have time to do so, you encouraged it by that little clip.
Yeah, that's good. That's good. It's just an indication that these, you know, sort of might call them peculiar aspects of property law, can crop up in ways that are unexpected and can have significant implications. And the reality of the operation of the rule against perpetuities is that if you don't have some understanding of it, and you're out there in practice, and you have a client that comes along to you and wants you to prepare their will, and they give you instructions in relation to disposition of property according to their will, and their instructions are that they're giving bequests or gifts, but not to happen just yet, insofar as not immediately on their demise, but they want to delay it a bit and this sort of thing. Well, if you don't, firstly, you need to obviously take your instructions clearly, that's the first thing. But if you don't structure the clauses and draft the provisions of that will in a way that is compliant with the rule against perpetuities in the jurisdiction in which you are performing this work, and we're looking at Queensland, but wherever you happen to be, then the effect and the consequence is that that gift, which was intended to be achieved by who at that time was your client, testator or testatrix, if it doesn't comply with the rule against perpetuities, it will fail and it will not be effective. And the consequence of a testamentary disposition that fails is that that property under the estate reverts to residue. And that is contrary to the intentions of the person that was your client at the time when you took the instructions, because clearly they wanted to do something with this part of their property. So that can be significant, and that's not consistent with what your client wanted. So understanding how the rule against perpetuity works is not unimportant. Having a broad grasp of the situations in which it relates to, and having an awareness that today the rule is an amalgam in most jurisdictions of common law position and legislation. Now in Queensland, that means common law position and then Property Law Act. Okay.
Michael, last semester, didn't we cover some information in regards to residue as well when we were talking about wills and estates back then?
What we dealt with in the Term 1 course was future interests, and we also looked at a little bit in relation to that in terms of succession legislation, I think at a point when we were looking at future interests, generally speaking. And that forms a bit of a backdrop to what we're discussing at the moment. So yeah, we touched on it, but not in the same way as we are in this topic.
Yeah, I think you made the point that we needed to get grounded in it because it would continue into this session this year. So
yeah. So that as you've seen from the various topics we've done, and my comments time to time that I make in class and in lectures, I often say, well, you will recall back in the Term 1 course, or you will, cast your mind back to, there are things that happen there that form a backdrop to our understanding of the operation of a more substantive area that we're discussing in this context in land law. So the rule against perpetuities is this amalgam of common law and legislation, and it operates in a somewhat technical way in trying to work out whether a gift, and it can relate to inter vivos gifts, that is during the lifetime of the donor, but it very typically operates in a testamentary context with regard to the will of a deceased person. And it's about whether those gifts that have been set up under clauses in a will, for example, are effective or not and have complied with this rule against perpetuities. Now, the rule itself, before we think about its technicality, it emerges out of a deeper idea, which is the first idea that's presented in this topic and in chapter 7 of your casebook, and that is this idea around alienation of property. Now, does anyone can anyone just sort of speak to that idea? What do we mean by alienation, and why is that important in land law?
Because they don't want property to remain unproductive, so they want it sort of, turning over, so to speak.
That's right, Peter. And this goes back again, harking back to the Term 1 course yet again. These are this, and even back to the first week in this unit, where we're asking, well, what is the purpose of property? What is the purpose of land? Okay, and yes, people own it. Yes, people have interests in it. They have rights with respect to it. There can be fights over that. There can be contests over that. But ultimately, land and other property, but in particular land, is important because of its utility. It can be used for various purposes, as we know. It can be used for habitation purposes, living. It can be used for commercial and industrial purposes. It can be used for agricultural purposes. Right? It can be used to grow crops, to build factories, a whole range of things, right? People can live on land as they need to do in multi-story dwellings, or on, detached dwellings and so on. So there's a utility with respect to the purpose of land. Historically, landowners, going right back into English history, were reluctant, basically, to let go of their ownership. And this sort of hand reaching from the grave to control the property, even after they've ceased to exist, was built into the arrangements that they'd put in place, or attempted to put in place, to limit the ultimate vesting of property, even though they'd set up a structure for it to be gifted and transferred. But it's complicated and convoluted in a way that the truth was they were trying to prevent the ultimate vesting. So there's this deep idea in the law that says that, in the general law, that says that, or holds the view that the prohibition of alienation of property is fundamentally obnoxious. You can't, it's not acceptable to tie up property forever and not allow it to pass forward into subsequent hands, because that just basically inhibits what the land can be used for and how it can ultimately be serve a purpose. So that was the general law's position. And it's out of that position that the rule against perpetuities arose, because the rule against perpetuities was a response to the attempt by landowners to construct restrictions around the divestiture of their property, so that, in a sense, it ultimately didn't vest wholly into the hands of those that it was supposedly ultimately going to be passed to. Now, the rule developed as part of the common law, but the problem was that the common law took a very strict view about how we were to understand the operation of this rule against perpetuities. And if you've had a look at the materials and you've had a look at, for example, in the range of materials that I've given you, there's reference you will have seen to the Air Jamaica decision, okay? And the Air Jamaica decision, which is a 1999 Privy Council case, it basically encapsulates, and this is, it's a more recent decision, but it encapsulates the common law position on the rule against perpetuities. And this is what the Privy Council said. So that the nature of the rule against perpetuities is such that no interest is valid unless it must vest, and if it vests at all, within a period of a life in being, the date of the gift plus 21 years, the rule is applied remorselessly. A gift is defeated if, by any possibility, however remote, it may vest outside the perpetuity period. It is not saved by the fact that in the event it vests inside the perpetuity period. Now, there's a number of dimensions to that statement by the Privy Council. There's this idea that to be valid, it must vest. What does that mean? Within a period of a life in being, the date of the gift plus 21 years. So a life in being, what does that mean? Plus the date of the gift of 21 years. Don't forget, this is the general common law view, right? And then if there's any possibility, however remote, of that not taking place, that is that the property will not vest within the perpetuity period, the gift will fail. And it's very strictly applied.
Can I ask you a question about then, just to clarify something, Michael? You said vest and then it's like 21 years from the date of the gift. Does that apply to whether it's inter vivos or via a will?
If it is applying inter vivos, then it applies from the date of the gift. If it's applying, if it's in the context of a testamentary disposition, then the operative period starts to run from the demise of the testator or testatrix.
Right, so that's what I wanted to clarify. So the reality is, if someone gives something to you while they're still alive, it's 21 years.
If the terms of the gift, right, are such that yes, they're trying to make a gift to you, but the way this is working is, if the property has been gifted to you completely, then this is not a problem. What this is dealing with is where someone is actually trying to prevent the full vesting of the property in the person that is being, in the donee, in the person to whom the property is being gifted.
Michael, one of the things that made me sort of really, I suppose, understand it was thinking back to the entailed estates in Britain. And considering there the fact that they didn't vest that property in it, they were totally entailed, those estates. And this sort of got me the same thing. And it seems to be that this rule against perpetuities was brought in to stop that sort of thing occurring. Would I be correct in that?
Well, I mean, that is also part of the history around attempts to structure how property could pass through certain mechanisms. And that's quite right. And in Queensland, fee tails, of course, have been abolished, again, through the Property Law Act. So there were these historical, things from the past where landowners were trying to basically lock up their property and not allow it to pass ultimately to a donee. So if you get a gift and it's full and the gift is complete, this doesn't apply. It's not relevant. This applies to situations where there are restrictions being placed on the full transfer of the interest to the donee, whether it be during the lifetime of a person, that is an inter vivos gift, or whether it be in a testamentary situation, but it very typically applies in a testamentary situation.
Well, I can understand the words in that Air Jamaica case from the point of view that these entailed estates and that were often gifted to the eldest heir, male heir, but the money that to keep them up went elsewhere. So, of course, the property was never sort of really used or worked to their full potential.
So this is part of, I mean, that mechanism that you've referred to, Peter, is, again, that was linked to the historical context within which property could be passed down, to subsequent members of a family, where within history, titles and so forth couldn't pass to female members of the family. There was limitations on that. A lot of discrimination actually embedded within those legal structures, which thankfully we've now done away with, and we've moved significantly beyond that situation which was there historically. So that's a little bit of part of it as well. But that idea was, so basically this mechanism was available to if you like, benchmark how what was the context within which a gift could be seen to be valid, even though it didn't happen immediately. You could still didn't have to vest immediately, but there were these elements that had to be established. And the TRIP one, right? So you've got that idea of, again, this is the general law, common law. You've got this life in being plus 21 years, and the life in being could be anybody, as long as it was a human being, a real person, and that they were alive at the time when the gift was operative. And even it could have been, you may have seen in the materials, reference to the Royal Lives Clause, because in some situations, again, it was another attempt to get around this part of the rule by putting in a clause that linked the life in being to the hereditary heirs of the monarch or of the sovereign. Again, this was an attempt to try and get around that part of the rule, right? So that's another dimension. But the feature of the rule that tripped, was tricky and led to some crazy situations, was this idea that even if there was the remotest possibility of the property not vesting within the perpetuity period, that is, perpetuity period being the life in being plus 21 years. And that 21 years, by the way, is arbitrarily chosen as a point of adult majority at the time when this was, this rule came into being. This prospect that there's just a possibility, even a theoretical possibility that it wouldn't vest, then this led to some crazy situations. And you will have seen in your materials situations referred to as the unborn widower and precocious children and the gravel pits. These were scenarios that gave the slightest remote possibility, even, for example, females that potentially were within the donee category, that there is this prospect that they could still be able to give birth to children, even though realistically they were beyond childbearing age and there was no practical way that could occur. But the very strict application of the rule meant that in that situation, a gift would fail in that scenario if that was part of the the donee group, or was the donee. And there are other types of absurd scenarios. Now, that was the general law position. Now, what we've come to is, in Queensland and in other jurisdictions, we have now got a reformed situation with the Property Law Act. But one thing that's important to remember is that we start from the position of the common law, and then we go to the Property Law Act in terms of the legislative reform. We'll come to the problem question just in a moment. Has everyone got everyone's here tonight, have you all got your case book beside you? Should be, yeah. Because the question is there in the case book. Now, I just want to read you something from Real Property Law in Queensland, because, and there's an extract of that from the chapter in Moodle, but I think it's quite useful because of the particular jurisdictional perspective of this topic. But what I just wanted to point out was that what they very usefully do there he says, you can't find it. Right, so you might just like to make a note of this. So on page, this is of the additional reading from Real Property Law in Queensland, Wallace, Weir and McCrimmon, page 207, they spell out steps to how to go about tackling a perpetuity problem. And on page 207, and they spelled out the steps a bit earlier than this, but they're just reiterating it, and then they're going to, explain the position under the PLA. Step 1, is the limitation contained in the instrument one to which the rule against perpetuities applies? So you've got to first ask the question, does the rule against perpetuities apply to what's going on with regard to this instrument that we're looking at, whether it be something during the life of a person trying to gift the property, or whether it's a testamentary situation. What is the date of creation of the interest? So this goes back to Nicholas's point. And we need to work that out. Who is or are the life or lives in being? So who's been nominated in the instrument or in the document? Don't forget, we're still looking at the common law position. Step 4, is it theoretically possible to construct circumstances in which vesting would occur outside of the perpetuity period? So this gives rise to that point about, well, is there any theoretical possibility that property could vest outside of the designated perpetuity period, which is the life in being plus 21 years? That's the 4 steps under the general law as described in Real Property Law in Queensland text. Then the authors proceed to point out on page 208 at the top, the Property Law Act essentially provides for a 5th step, okay, which may save the interest once it is clear that under the general law, the limitation offends the rule. So once you've gone through those 4 steps, if the outcome then is, well, yes, the rule according to the general law is offended and the gift will fail, we then go to the property law provisions to try and save the gift. So the authors then point out, when applying the 5th step, 2 points must be kept in mind. The legislation, this is the Queensland, the PLA, and this is currently, and I'll talk about reform in a moment, which is important as well, okay? The legislation applies only to instruments taking effect after 1 April 1973. So that's the first point. It's only to instruments post 1973. And in most but not all cases, the legislation modifies but does not abrogate the rule against perpetuities. It modifies, but it does not abrogate the rule against perpetuities. So that's why I said initially what we have is an amalgam of the general law or the common law rule plus the overlay of the legislative reforms, in our case, reflected through the PLA. So, step 5, to summarise, as the authors then do for us conveniently, can the limitation void under the general law be saved through the application of the statutory modifications to the rule contained in the Property Law Act Part 14? Now, I've done this on the lecture, but I'll just share it with you again at the moment, which is hopefully people will find that helpful. So we have Part 14, as you can see there on the left, dealing with perpetuities and accumulations. Okay, section 206 to 222. And there is a range of sections there that are relevant, that are helpful in trying to save a gift that would otherwise fail because it falls foul of the general rule against perpetuities. And I suppose there are a few things that are important. So, for example, section 209 gives us the opportunity to specify a perpetuity period according to the legislative scheme. You can see there, under sub 1, that the period is 80 years. Okay, so the period under the general law is a life in being plus 21 years, but you can specify the statutory period of 80 years. That gives you, a longer period within which it is possible for the gift to vest without failing. That's the long and short of it. But we also need to be aware that okay, pull it up anyway. It's slow. I'll just mention it. That it's in the lecture anyway, but I'll just mention it. That remember that there is this review of the Property Law Act that I've given you. Okay. Now this review, and as I said, it's a substantial document, but I'm not at all expecting you to read the whole document. But in this area, there is a chunk dealing with Part 14. Now it's a fairly long chunk of the report, but you certainly don't need to look at all of that. But it's clear that there are some important reforms there, okay? And one of the reforms that is being proposed is that the perpetuity period be actually 125 years. And there's a range of other things there that you can have a look at that are discussed in the report in regard to the discussion around Part 14. And so that's interesting that this period, which clearly, it's already in the Act, it's clearly, quite a longer period than under the common law period of perpetuity. But what's being proposed is even a longer period, 125 years. And indeed in the UK, the period is 150 years following reforms. And I think it's 150 years in New Zealand too. The whole purpose of these reforms is to enable as much as possible for a gift to actually be able to be effective and not fail. That's part of the rationale, okay? But the creation of a statutory perpetuity period is only one aspect of these reforms. We also have in section 210 something that's quite important that's been introduced, and that is what's called the wait and see rule. Now, the wait and see rule has been introduced to overcome these what are arguably absurd or ridiculous outcomes from the very strict application of the common law rule. So basically, the wait and see rule under section 210 is that the court will, or the law will wait to see whether or not the gift will vest during the perpetuity period. Now, of course, we've got that longer perpetuity period, then we're waiting and seeing for a longer period of time. But this wait and see overcomes this idea of if there is just this theoretical possibility that it won't vest, even though it may actually already have done, but there is still this remote possibility, then the gift will fail. This overcomes that, because if we wait and see, and the gift actually in reality does vest within the perpetuity period, then it's valid. There's no issue. So section 210 on the wait and see is quite important. That's on page, just go cross-referencing back to Real Property Law in Queensland, page 210, dealing with that. So the authors there say, for example, that section 210 attempts to remedy this mischievous and unfortunate result by allowing the court to wait and see whether the interest will vest outside the perpetuity period. The mere possibility, no matter how logically improbable or remote, that an interest will vest outside the period is no longer fatal, because the court or the law is now waiting and seeing to see if it actually will vest within the perpetuity period. And depending on what the donor, testator, testatrix has provided for, we might be talking about life and being in 21 years. We might be talking about the nominated period of 80 years. And if no period is specified in the instrument, then we will divert to or revert to the statutory period under section 209. Now, the legislation has other provisions that are dealing with some of those scenarios that came up in the application of a common law rule. So, for example, section, I don't want to go into these ones, there's another one I want to talk about in a minute, but presumptions and evidence as to future parenthood, section 212, unborn husband or wife, section 214. Also remember that there's a commercial application of this rule, so that, for example, section 218 deals with options with regard to, for example, an option to renew a lease. Okay. And the other point that comes up in the other case that I've given you on Moodle, and that is the Nemesis case, is that very typically today, the instrument of a trust is used in sometimes in a commercial situation, unit trusts and so on. And that is something, and that is a context within which the rule can also be brought up for discussion. I mean, in the Nemesis case, this involved an action against the Commission of Taxation, because the Commission of Taxation was trying to tax monies in a trust and trying to suggest that it should have access to this, and that there was discussion around the application of the rule against perpetuities in the facts that were relevant there in the Nemesis case. So that's also something you can have a look at. I've given you a copy of Nemesis, and there's a good discussion actually of these provisions in the legislation from the PLA in that case. But the other point that I just want to bring out, which is quite important in terms of the legislative reforms, and that is what's referred to as dealing with class gifts, and what are referred to now as the class closing rules. And find those. So when we look at section 213, actually just go back to 210 for a sec, you can see 210 refers to section 213. And then when you go to section 213, you can see that that is about reduction of age and exclusion of class members to avoid remoteness. Okay? Because the issue around gifts to classes of donees or beneficiaries was that if one member of the class was to take outside of the perpetuity period, then the consequence very often was that the entirety of the gift would fail, not just for that member of the class, not just for that member whose portion or share was going to take outside of the perpetuity period, but would affect the entirety of the class because it was a class gift. This provision is intended to deal with that, to avoid this idea of remoteness. And again, the purpose is to try as much as possible to enable the gift to be successful in terms of how that was intended by the donor or by the testator or testatrix. So we have the, section 213 deals with what's referred to as reduction in age and exclusion of class members to avoid remoteness.
Michael, can I just reflect on that for a minute? Yes, is it possible to suggest that where you have an interest passed over, and yet in any documentation there is no time presented? Because, and I say that because I think it's an important factor in relevance to the rest of the comment, which is section 29, 210 and 213 seem to almost outweigh the issue in the general law of step 4 as you equated to it earlier. Step 4 being the practicality of whether it will transmit or not.
That doesn't outweigh it. What happens is the way this is working is you need to see whether or not the gift fails according to the general law rule first, and then you go to the legislation. The legislation doesn't replace the rule, as I pointed out, but it seeks to deal with, if you like, the mischief that the rule has created through its very strict application.
But one of those mischiefs that I'm trying to point out is the fact that inside any of these documentation where you're handing over an asset, if you haven't specified a time frame, then that's where the additional rules 2.9, 2.10 and 2.13 come in, because it's going to be outside of that vested time, because the vested time wasn't analysed.
Not only that, Nicholas. So if there is no perpetuity period specified, then we'll revert to the perpetuity period that's now under section 209. Yes. But even if there is a perpetuity period specified, a life in being plus 21 years, other provisions of the PLA may be able to be used to save a gift that would otherwise fail for non-compliance with the general rule against perpetuities.
E.g. Rule 213.
Yep.
Where that kicks in right now. Yeah. Okay.
Yeah,
I'm just trying to put it all together so I can.
Fine. And we're just going to have a look at the problem question momentarily. But I didn't want to. The reason I've done this, folks, is I just didn't want to. Firstly, people are involved in assessments and all this sort of thing, and I'm not entirely sure how much you're across this particular topic. But just throwing you straight into the problem question, which is basically quite computational in terms of using the matrix of the general law and the PLA provisions. I don't think we're going to achieve a lot just by going straight to that. So I wanted to give you a bit of an outline around that. And so we just finish off on this point. So we've got section 213, so that the situation that arises is, very often there can be, typically you could have a situation where, say, in a testamentary scenario, you've got someone who has grandchildren and they want to give something to their grandchildren, but they put certain restrictions on when they can get that. So it might be around a certain age, or something they've done, or something they need to complete something before they can get access to their gift. So it's held on trust until that time. That's a scenario that's likely to fall within this idea of a class gift. And then if we've got different ages and these sorts of things with different requirements about that, if that's how it's been structured by the testator or the donor, that's a scenario that can fall foul of the rule. Okay, so on the one side, as a lawyer that is getting instructions to draft up a will, one has to take care to ensure that the clause is compliant with the general law and the legislative requirement, and a way to ensure and so the purpose here is to try and make the gift be successful as far as possible. So from the drafting side, right, that is in preparing the will, trying to fireproof it in a sense, if you want to put it in those terms, and to get away from the scenario in body heat, right, of the lawyer in body heat. The way you would do that is by, using the legislative provisions in a way to ensure the gift actually does not fail. So by using the statutory period of the perpetuity period, which is much longer, by utilising the other aspects of the provisions there for class gifts and so on, right? But if you're on the other side and you're dealing as a lawyer with a dispute where, for example, you've got someone coming to you and saying, look, I'm a beneficiary under a will and I can't get access to the gift or to what I think I'm entitled to, what's going on here? Well, you're not in the process of drafting the clause, of course, for the person setting up the bequest or the gift. You're dealing with the consequence of that. But what you're then trying to do is interpret the situation, and you would explain what the law will do is interpret the situation to try and make the gift be operative through firstly looking at the common law position, but then going to the legislation to see whether or not there's any way that in fact it can be salvaged and the gift will be able to pass to the person to whom it was intended. So the class scenario is a particular subtext or subgroup, if you like, of that. All right, so that's all by way of discussion around the topic, folks. Let's have a look now at a bit of, we're not going to work through the whole thing because it's a bit too much, but let's have a look at the problem question, which I set out for today. Now you will need access to your casebook for this. And let me see whether I can actually, might be able to.
Just while you're doing that, Michael, can I just clarify that last point that you made about dealing with an issue where somebody's coming to you and saying, look, I think I've got or should have access to property X, Y, Z through a will.
Yep.
That will, does it or is it reflected in the time frame in which it was written, or like actually when it was executed? Because there's that issue you said earlier of post 1973 and the legislation. I'm just wondering how that factors in.
That the interest becomes effective. I mean, if we're talking about a testamentary situation, then the interest becomes effective at the death of the donor, the death of the testator or the testatrix. Now, if that death occurred prior to 1973, or that specified date in 1973, then the provisions under the PLA do not apply. It has to be post that date in 1973. Now, the fact that we're in 2019 would hopefully suggest, and as we continue to go forward, that we're going to be dealing with situations that are able to be dealt with and salvaged, if need be, under those provisions of the PLA. But yes, you do need to be aware of when the legislation becomes operative. Just because there is an act in place doesn't mean to say that it's universally operative. It can be specified in terms of when it takes effect, and that's just an aspect of knowing that about legislation and its legal effect. Yeah, so that's true. So you could well have a situation. It is conceivable that you have a situation to which the reforming provisions of the PLA do not apply. That's possible. But hopefully going forward, with years moving forward, that will become less and less the case. And one would hope that most situations that one is confronted with gives rise to a consideration of both the general law position and the reforming provisions under the PLA. So we've got this problem question, right? So we've got, and this is just replicating the information that's there in what is example 37 of your casebook. So we've got a gift to A for life, remainder to A's grandchildren, who being male attain 30 and being female graduate in law. And so you can see already that the testator is putting restrictions on the passage, on the transfer of the gift. Right? So this is a typical scenario to which the rule against perpetuities is relevant, because the gift is not, I mean, if the testatrix was saying, I give this property to my brother or to my son, full stop, no issue, because the gift has been entirely transferred. The property has been entirely vested. If it's been entirely vested, there's no issue, right? Rule against perpetuities is dealing with these situations where the gift is being made contingent upon various things happening, and maybe with the intention of preventing the gift from ultimately vesting, right? Or taking a long time to ultimately vest. So you've got that information, and then you've got some additional information. So you're told that that A was 5 years of age in 2006 and dies age 70 in 2071. That's right, isn't it? Is that right? I hope it's right. I hope it's right. That we've got grandson 1 who attains the age of 30 in 2060. We've got in 2071 there are 8 grandsons aged 8 to 41. that we've got grandson 5 is age 13 in 2071. We've got grandson 9 and 10 born in 2072 and 2073. So you've got information about when particular grandchildren or grandsons were born. And notice we're getting information about grandsons and then also about granddaughters, because there are different restrictions placed upon whether the grandsons, the males, take their share or the females take their share. And also the fact that we've got, first of all, we've got to A for life, so a life interest, okay? And then the remainder to A's grandchildren. Now, the fact that it says it expressed it like that, what sort of a gift does it look like? If this gift is going to a whole bunch of grandchildren, what does it look like? Just generally.
They're a class.
Right. So immediately we see, and we're on guard that this looks like it's a class gift. So we immediately then have to think about, well, does that mean that if one of the members of the class don't take, does that mean the whole gift to all of the members of the class fail? And if that is so, then we go to the PLA reforms that are about trying to operate on a class gift to save the gift by applying the class closing rules. So we've got that information there with regard to birth and death. Most typically these scenarios, folks, involve birth and death and all of these things. So we're told that one of the granddaughters, GS3, dies in 1965, age 24. GS4 dies in 1975, age 24. GS6 dies in 2080, age 20. Granddaughter 1 graduated in 2065, but unfortunately she's also died in 2067. And in 2071, we have 3 granddaughters that are alive. That's GD 2, 3 and 4. None have graduated. And we've got GD 5 and 6 that are born after 71. So this 2071 seems to be a critical date. We'll look back up here. We saw that A was 70 and A died in 71, right? And we saw that the gift is structured in a way that A gets, what does A get?
Well, A gets it for life. So A had it for life until they died at 70 in 2071. So
when the life estate, when the person that takes the life interest dies, that's when the other gifts become that triggers the process for the other gifts, right? So that's why we see 2071 coming up. So, and we've got information here. In 2071, 3 granddaughters are alive, as I said, GD 2, 3 and 4. None have graduated, and we know that the gift talks about if being female graduated in law, right? So that's a qualification according to this test data, right? That this instrument. And we then have GD 5 and 6 are born after 1971. So they're born after the time when this gift first, this dimension of the instrument becomes operative. So we've got that information. And what else have we got? In 2086, GD2 and 6, they have now graduated in law. So they will have met that qualification or that criterion within the original instrument. Right, so we're now, with that information, I know it's a bit involved, you can see this is at 7.82 of your casebook, okay, page 692. Who takes how much and when? And in analysing this problem, it may be useful to consider the following questions. When does the class close? Because clearly there's a class gift, right, as we identified, right? When does the class close? Who wants to have a shot?
2092.
92? 2092?
Yeah, because that's the life of being of A plus 21 years.
No.
No, I'd run the rule.
It's 86.
Not 86, no.
I'd run the rule 213 in the PLA to work that out.
What is it that allows the class to close? What triggers the operation of the class gift? We go back up here, we have a gift, a life estate being given to A, okay, and then we have the other dimension of the gift is in effect a class gift, but it becomes effective when?
Does it become effective when A dies?
Yes, yes.
Yeah.
Yes. So what we have is that the class closes when A dies, okay? Because that's what then permits us to work out whether or not we can save this class gift, okay? So it's 2071. The next question is, when does it become apparent that some grandsons will not fulfill the age contingency? All right, now if we go back up to the information, what was the age contingency again? That the grandsons had to attain the age of 30. Yeah?
Well, most of them died before then, so it's irrelevant to them because they're dead already. So you just subtract them out of the equation straight away.
Yeah, but we have to, so the question is, right, when does it become apparent that some grandsons will not fulfill the age contingency? Anyone able to have a shot at this?
Is it if they're not 30 before the cutoff for the class because they're still part of the class?
They need to reach that age to qualify to take under the provisions of the instrument, right? But again, this is when A dies in 2071, okay? Because that's the trigger date for the operation of the class gift, okay? We'll try another one. I don't know how we're going so far. How old will GS, now this is a computation one. How old will GS5 be in 2086? Since he will be the eldest grandson under 30 in 2086, is the age of the class reduced to the minimum age to satisfy the gift to him? And if not, why not? Are we able to work that one out? How old will GS5 be in 2086? I must have worked that one out. When was he born? GS5.
28.
28, yeah.
28? Yes, exactly. Right. And there we go. So we've got, there's 28, and no, the age is reduced so that the youngest at the time it becomes apparent, which will be 20, the youngest will be 23. So in other words, the the operation of the provisions here under the PLA allow the class to close and it's about reducing the age so that the youngest at that time, when the class closes, enables the gift to be effective. All right. So we might try one more. GS9 and GS10 take nothing. Well, GS9 and GS10, where are we with them? GS9 and GS10
born after 2071.
They were born in 2072 and 73. So why did they take nothing?
Because they weren't born, the unborn child.
They were after. Where are we up to?
After the initiation of the will, which is 2071.
2071 is not the point of initiation of the will. 2071 is when the person with the life interest dies. Okay, so the property passed as on a life interest to A, and then on A's death, it then passed as a class gift to grandsons and granddaughters, according to criteria specified in the instrument or the will. Okay.
So Michael, what was the start date of the will then? Like, was it 2006?
The start date of the will. The testator died in 2006, right? So the will was made in 2005, and the testator died a year later. Okay, but the property was with A until A died, which is until 2071. All right. So that's when the testator died. Okay. And where were we up to? We did this one. We did that one, right. So GS9 and GS10 take nothing because they were born after the class closed, because the class closed in 2071, which was when the gift passed or was intended to pass to or become operative in favour of the members of the class following the death of A, who had the life interest. I'll put this up for you on the Moodle site, okay, as a worked solution around this, okay. These sort of puzzles and problems, folks, I'll just stop screen sharing that. These sort of puzzles and problems in terms of the rule against perpetuities are, I know that they look like, you know, they're a bit computational and a bit mathematical, and they are, right? But it's just bearing in mind the essential factors and what the purpose of the rule is, its various features, that's under the common law, and then how the provisions under the PLA operate effectively to try and save the gift, both through making provision for a statutory perpetuity period, by instituting a wait and see approach rather than the common law's approach of if there was any theoretical possibility of the gift vesting outside the perpetuity period, even though that was remote and unrealistic and crazy, it would fail. So the wait and see mechanism under the Act allows us to see if it will vest within the perpetuity period. And then under Section 213, we have mechanisms to close the class and reduce the age of the beneficiaries under a class gift, again, to try and save a class gift. Because under the common law rule, if one of the members of the class was to take outside of the perpetuity period, the gift for all members of the class would fail. So it's important to remember that that's the driving purpose of both the common law rule and also the way in which the provisions of the PLA are operating. But, and I want to just finish on this, it's important, really important, to understand the underlying purpose And it's important to see it in the context of this idea of that the common law will not accept and will not countenance restraints on alienation of property. And it's really important to also be aware of these reforms that are proposed with regard to Part 14 of the Property Law Act under the Property Law Review 2018, because they are making suggestions to further improve the situation. And as I've indicated, one of the significant recommendations is to extend the perpetuity period from 80 years to 125 years. That's quite significant. But it is also consistent with reforms that have been introduced in other jurisdictions and other parts of the world to try and, again, ensure as far as possible that gifts that have been created by instrument, and clearly, you know, there's an intention for the gift to pass to donees in the end, that they can be effective according to the terms of the instrument and the intentions of the maker as far as possible and practicable, rather than failing because of the very technical way in which and strict way in which the common law rule has been applied since its introduction.
I guess I could see a rationale behind that potential for change to 125 years, because I guess when the original one was written, 21 years would have seemed well and truly a long time at that time that law was written. And when it was adjuncted to 80 years based on the lifespan of a human being at that time, and considering the lifespan of where humans are going and how far you could cast forward of what you wanted to do with your assets, moving to 125 years seems to make more and more sense.
That's the purpose, but don't forget that the perpetuity period under the general law was not 21 years. It was a life in being plus 21 years. And that life in being needed to be a real living human being, or I gave you the example which has been used, and that's what's referred to as the Royal Lives Clause. Again, attempt to try and partially get around the operation of the rule, but it still is viable. But it's not just this 21 years, it's a life in being plus 21 years. But the point is that, again, it was still only a fairly modest number of years. Why was the figure 21 chosen? Because at the time when that was thought about, that was the age of majority for an adult, 21. Okay, so even that's a bit anachronistic, really. But that's the perpetuity period under the general law. Currently under the PLA, it's 80 years. The proposal for reform is 125 years. You can see the tendency here is to create a much longer period to enable the gift to vest and not to fail. That's the reality.
Other than exceptionally wealthy individuals, though, that would be looking forward to the proximity of their family 125 years from now, how many people would actually sit down and write out a will that would vest in their great-grandchildren?
But as I said before, Nicholas, this is not only happening within personal situations, so that, as the Nemesis case indicates, this can also happen in the context of unit trusts and the trust. And, you know, obviously you do a course on equity in trusts, or two courses at the moment. And the trust, although initially coming out of the context of individuals doing things, today it is very much taken up in commercial situations as a mechanism of dividing interests in property. And it's in that context that the rule against perpetuities can have work to do. And of course, if you're talking about the management of property by trustees that are companies, then you know, the issue around the management of that property over long periods of time is of a different dimension. So one of the things
there's utilities within the Trust Act to deal with those sort of issues, because the trustee has to actually manage the property, thus back to put the property to use.
That's right, but the point that's in terms of doing things with the property during the continuance of the trust. But what we're talking about here is that the property that's upon trust, what are the mechanisms for its ultimate divestiture to the donees to whom it is intended to go ultimately? And that's where this rule becomes relevant with regard to the instruments that create that, not in terms of the responsibilities and the work that the trustees do whilst property is in trust, if you like.
Right. So
but I was just trying to highlight that it's in those environments that, and within commercial situations, that gives this sort of rule more vibrance, if you like. It's not just when you mentioned about, well, are we only really talking here about wealthy people that are trying to do all these crazy things with their property? Well, today, the sort of, convoluted structuring of provisions within wills and so forth. Yes, I mean, ordinary folk, I don't think reasonably, mostly they're trying to do that. And where that comes out of is history of landed gentry trying to do that with significant land holdings. Yes, but in the modern period, this whole issue about the relevance, this tosses up the idea of the relevance of the rule against perpetuities. So that sort of, landed gentry type scenario is not something that is common in this, in Australia, although we do have wealthy individuals that are trying to do things often in convoluted ways with their property going forward. You've only got to, the Reinhardts and her father, who was the mining baron in Western Australia. Those sort of things can happen as well. But the other dimension is in the commercial environment. And so one needs to be mindful of that in terms of giving, thinking about the relevance of the rule today in light of where it came from historically.
Okay, so if you have a corporation that has a trust, and it's on the completion of the trust, it dispenses a part of the assets to another corporation, that becomes quite enamored in this issue within the PLA, doesn't it? Because that's primarily what the PLA is dealing with, rather than the aspect of the trust itself. It's the disposition of the assets within the trust. Yeah,
That's right. And what's going on in that environment is that basically, and I don't know how far your studies have extended, but there are tax implications. Historically, there were tax, income tax reasons why people would set up trusts in regard to the division of income from property earning, income generating property, put it like that. Now, in that area, the law has been tightened up significantly than what it was historically. But there are still reasons why interests in property get divided, and the trust is a mechanism that's used to do that. Very typically today, in the modern Australia, to achieve business or commercial objectives or goals. But that's not where the trust originated from, right? In your trust law studies, you'll know that, or if you haven't studied trust law, when you do study, you'll come to learn that the discussions and debates are very much about historically, about individuals and about the roles they played in terms of dividing interest in property. But today, that still happens, yes. But today, there's also this dimension of in commercial situations involving businesses and companies that is also part of the environment, and then we just need to think about, in that scenario, well, does that change our response to the idea around the rule against perpetuities? What I mean, in the material that I've given you, apart from working through the mechanics of understanding how it applies in different, scenarios or problems, there's discussion in the materials about, well, is this rule really any longer relevant? We're talking here about some anachronism from ancient English history, right? And the way that it's been applied, leading to absurd outcomes and so on. Are we happy with that? Is that really the way the law should be functioning today? And we see, and I've already mentioned to you, we've got this amalgam situation between the general law and the legislation. And you might say, well, but Michael, that's hardly a satisfactory situation. Why haven't we got just a total reform and doing away with, all these challenges and difficulties within the common law rule as well? Well, that raises interesting issues about its ongoing relevance in its current form, its applicability, where it came from originally and how it functions today. And there's a whole lot of issues there. And there's some materials you can have a look at in your that I've given you in different places, in the notes and in discussion in the case book and so on, about that background and that context.
Well, you can't just dispense with the background, can you? Because it's like saying, well, I have a tree house, and if I cut down the tree, will the tree house still stand? The answer is no.
Yeah, you can't dispense with the background, but you have to ask, despite the background, is it still relevant today in the modern period? And this is a question that the law needs to tackle on an ongoing basis. We have a lot of dimensions of the law that come out of a context of the past that has changed in terms of how it's being utilised and applied today. So and law is of a nature that you can't, one doesn't normally just dispense with it, but how do you respond to the different dynamic within society today, and does it continue to still serve the purpose?
Well, we have a movement towards plain English speaking and writing in the law, so I would imagine over a period of time, all those exchanged words that we talk about will be given a plain English relevance moving forward.
Well, the language, of course, it needs to be clear in its communication, but that doesn't touch the rationale. And if that's an issue, then that's another dimension of the discussion. Look, it's now 8:20. I'm going to call it at a close there, folks. Now, what I'm going to do is I'm just going to pause the recording. We'll take a 5-minute break, and then I'm going to come back in for maybe about 20 minutes, and I'm happy to take, if there's any questions, a bit of a Q&A on the 30% assessment, if people are interested in that, and any other questions or issues you'd like to raise. So we'll take a 5-minute break. I'm just going to pause the recording, and then we'll come back and have about 20-minute Q&A. Peter, do you
I can't stay, Michael, but thanks very much.
Okay, that's fine. Look, I want to ask, is that something that are people wanting to stay for that, or would you like me to offer some other time, or I can do that?
Well, I can't stay either, Michael. I've got a ton to do, but
yes.
Even if you just did a video with general comments about it and posted it up on your own, I think that would be a good start. Maybe we could communicate about it more next week.
All right. Are people happy with that? Those that haven't spoken, I mean. Husband says yes. Eve, you happy with that?
The assignment's due next week, isn't it?
Shana, sorry?
The assignment's due next week, isn't it?
The assignment is due tomorrow week. Yes, it is, ma'am.
Yeah. I just have a couple of questions to ask, so can I talk to you after?
You can stay on the line, and I'll just if I can just get a quick cup of tea, and then I'll come back and we can have a chat. Is that okay, Shana?
Yeah, that's great. No rush.
Okay. And look, you can just stay on the line or stay on the Zoom session. I'll just pause it for 5 minutes. Anyone else that wants to stay can stay. Anyone else who needs to go, no issues. And then and I'll offer some more time if other people would like that. Okay. So I'm just pausing the recording for 5 minutes, then I'll come back. See you soon. Okay.
Yep.
Right. So just speak up a bit louder so I can hear what your questions are.
I just have 2 questions. One question is our mark getting released for our last assignment tomorrow?
That's my expectation. So I'm hoping to be able to do that. Yes, hoping to be able to release marks tomorrow, and feedback on assignments. By the end of tomorrow. That's my aim. Yep.
Okay, great. And also, with this assignment, what exactly are you after in question 1?
Well,
like, I don't really understand what I'm actually supposed. Like, I know I'm supposed to be comparing priority notices and caveat, however you say it, caveats, whatever.
Caveat.
Yep. That's it.
So, what is it you don't quite get about the question or the task?
I actually don't understand the question. I don't understand what I'm supposed to be doing.
Right. So what I've asked you to do is I've asked you to give a presentation to the partners of your law firm. Just imagine you're in a law firm, okay? You're a solicitor in a law firm, and they've asked you to give a presentation on the differences between these 2 mechanisms. And the question also talks about, well, is one going to really become, more the one that we look to rather than the other one? And we want to hear about those, and we want to hear about what's the relevant of electronic technology and e-conveyancing in terms of these different mechanisms.
Okay.
So what is it you're unsure about?
So is that bit about if we think one will, become like to do with the e-conveyancing, is that basically our opinion, or?
Well, it's a reflection of what what you see, what you see in the mechanisms. In terms of the electronic conveyancing aspect, there are materials on the Moodle site from PEXA, right? And those materials explain different things and different mechanisms that you can use, including the ones that I've asked you to focus on in terms of the presentation. You can have a look at that and think about, well, does that change my view about how these 2 mechanisms get used? In terms of your presentation, it's also about explaining the differences between them. It's explaining, do they have different roles? Is one more, easier to use than the other? And how does the electronic conveyancing environment affect that? Does maybe the electronic conveyancing environment facilitates the use of one more than the other? Possibly. That's a matter for you to decide. Yeah.
Okay.
Does that help a little bit?
Yeah, it does. Yeah. Okay.
But remember, the focus is it's a presentation to the partners of the firm. Okay. So it's not just, what if I can push this back to you, what will the partners of a law firm be interested in?
I have no idea.
No idea. What are the partners of a firm? What are they doing? Are they just lawyers, or are they more than that?
I don't know. I'm assuming they're more than that.
Well, the firm, what is the firm? Is it just about doing legal work, or is it effectively, what is it?
I don't know. I just assumed that it was legal work, obviously.
Well, legal work is being done in the firm, yes, but at the end of the day, if it's a firm in private practice, effectively, what is it?
Don't know.
Does money come into the firm?
From like billings, yeah.
From clients? And
Yeah.
And what do you do with the money? What happens to the money that comes in from clients?
Goes into a trust account.
No, I don't mean money that's coming in on behalf of the clients. I mean that money is coming in from the clients for for services rendered. Where does that end up?
Is it more like distributing money between all the partners and just telling, or just how could I say, just more like telling the other partners, like as you said, we have to brief this reflection to the other partners, and then just maybe making more into the knowledge and more like into the discussion into that.
Yes, that's an aspect, Usman. And I mean, what I'm wanting to get you to grasp here, folks, is that a law practice is not just about lawyers solving legal puzzles and giving legal advice. It's actually a business. This is a business. These lawyers are together in a partnership making money and doing things by, yes, providing legal advice and whatever. They're running a business. So when you're talking to a partner, you've got to remember that they've always got their business hat on to some degree, because this is a firm that needs to survive. And guess what, folks? Legal environments today and law practice environment is actually quite challenging. And the revolution of technology is making it even more challenging, putting resources under stress, putting the need for lawyers and the need for extra staff under stress, because technology and automation means actually in the end, you probably need less folks around. But there's still this driving desire to make the business successful. So partners want to hear about things that are going to be good for their business, as well as they need to be informed about legal developments. And of course, that's part of being a professional and being a lawyer and so on. But there's this other dimension that we can't ever lose sight of. When you go out there and if you work in practice in a firm, the firm needs to continue to be successful to survive. And in a very competitive environment, and with the implications of technology, including electronic conveyancing, this is becoming increasingly a challenging environment for lawyers and for law firms. So that's another aspect to think about, linking it back to the substance of that question in terms of the things I'm asking you to reflect upon. But how would you go, I mean, and what I'm trying to get you to do is think about, in presenting back to the partners, to be aware of those dimensions of their interest. Does that help a bit, Shana and others?
Yeah.
Sort of comes down to the law firm though, doesn't it, too, and who specialises in what, because what the suggestion is that I'm getting from the question is that you would have you as the individual in this case being tasked with learning as much about a particular type of interest within the law, keeping abreast of the changes within that interest.
Right. Now, this is interesting, Nicholas, right?
Yeah.
So this is so Shana's question I thought was interesting, right? In terms of, well, Michael, what's really going on here? Tell us what, you need to think about the purpose of why I'm setting the question, okay? So the purpose is I'm deliberately asking you to give a presentation to the partners of the firm. So this is not just about transfer of information, okay? Oh, I'm here today to tell you all I know about this area of the law. Right, thanks for that. I've got things to do, right? That's what the partner's response will be, right? So they expect you to present, they expect the presentation, obviously, to explain things about the subject matter you're talking about. But the purpose of the exercise has a few purposes, really, is to get you to think about what is, when you're presenting to the partners, what are you actually presenting? So you're presenting information, yes, you're presenting about the subject matter, yes, but you're also trying, maybe, let's say you are a property lawyer, and Nicholas's point about, well, not everyone in the firm is property lawyers, well, we understand that, right? But maybe this is an opportunity for you to showcase to them what's going on in property law. Maybe this is an opportunity for you to showcase electronic technology or electronic conveyancing through the mechanisms that you're talking about, which they may not be otherwise aware of. The other thing is when you're presenting, so just imagine, I'm asking you to put yourself in the shoes of being an employed solicitor in a firm presenting to the partners. What sort of opportunity is that for you?
A pretty big one if you have information that they're not aware of that directly relates to their issuances within their particular strata of law. It's that,
but it's also about showcasing you. I can tell you from personal experience that it's not every day of the week that you get to do a presentation in front of all the partners of the firm. This is an opportunity of you showcasing you, all right? So you might say, well, how does that relate to property law, Michael? Well, it's about getting you to think about the explaining of property law and things within the land law and property law environment to other professionals who are people running the firm that you're involved in, and being able to explain things to them so that it shows that you've got a certain level of expertise around this area. But it's also presenting to a different audience, right? As lawyers, we present to a whole lot of different audiences throughout the course of our careers. Now, in law school, we often, not always, I mean, you know me, I set up different puzzles for you, but the more conventional type of exercise is a problem-solving question, and the other two questions in the assignment are a bit more like it. Conventional problem-solving questions that are focusing on advising a client. Yeah? But lawyers increasingly are presenting to a whole range of different audiences and are involved in a whole range of different things that involve the law, but very typically involve them having to communicate and explain the law and the technicality of the law to other audiences. Now, just imagine if you're talking to the partners of the firm, this is to get back to a couple of points that were made. Not all those partners are property lawyers. So they're not necessarily across this area. They're not necessarily, in tune with all of the minutiae and all of the technicality and the latest developments and whatever. And if they're not in property law, which some of them obviously wouldn't be in property law, they're not going to become property lawyers, but maybe they're interested to know what's going on, interested to know the current development. How are you going to make that interesting for them? How are you going to get their interest? A presentation is something that is of a different, character to just documenting a response to a problem puzzle, for example. It's getting you to think about that different situation, that different environment. That's why, in a way, I'm giving you the opportunity to do it in using different types of media. Right? Yes, you can do it as a document, but you can also do it as an audio, or you can do it as a vidcast recording, because it's a presentation. Okay. Now, I've given you the option to do that. It's not a requirement, because I like to give my students options around these things, but I want to encourage you to think about using technology to make your presentation more interesting and more vibrant for those you're presenting to.
In that essence, Michael, can it be a screencast video rather than a video of yourself giving the dialogue?
Can you clarify that? What you mean by that, Nicholas, please?
Well, obviously, technology now allows us to record the screen of websites that we're on, as an example, or run a PowerPoint presentation like you do and record it. Thus, you're not on the screen, but you're articulating what is on the screen. Yeah.
Okay. So, okay. Hoping, of course, we're not going down the pathway of deep faking. Okay. But one thing is, if you do a multimedia recording, I do need to have verification of identity, so that you are actually involved in the process. It's not just, you might hypothetically, you might say, oh, here's Pex's recording. It's fantastic. There it is. Look at it, right? No, that's not good enough, because I want a presentation from you. But Nicholas's point about being a bit creative in using material, yes, I'm happy with that, but there needs to be involvement by you and a verification that is the case. Okay. And I put that statement there with regard to those sort of things.
Yeah, so if you were talking all the way through the screencast and not just showing another video as an example where somebody else is talking, as long as you were talking through the entire process, that would be enough clarification?
That's enough, so long as you also, and Sian's got a question, I think I'll come to you in a minute, just, make a statement at the beginning, say who you are, identify yourself, that sort of thing. That's really important, needs to happen, okay? And the fact that you're giving the audio and you're talking through and explaining it, but you're using other things, it's not just you on screen, that's fine. That's fine. Sian, did you have a further question?
Yeah, just if you do it by yourself, obviously if you type up 850 words for you to present, it's not going to take 10 minutes?
No, sorry. The 850 words and the 10 minutes are, you could do an 850 word document, or you can do up to a 10-minute recording.
Okay, cool, yeah.
That's not intended for you to do an 850 word document to be presented in 10 minutes, okay?
Yeah, I was just thinking, if I did write a document that was about 850 words and then, presented it, I think it would be a lot less.
Yeah. No, but what you might find, and this is the experience of most of us that do recordings these days, is you would need to decide how you're going to go about your presentation. So you might need to make some notes. I mean, obviously you make notes, but you might need to do a little bit of a script or a little bit of a, sort of guidelines of how you're going to structure your recording, how you're going to do. If you do a recording, there's a couple of dimensions. So you need to think about the presentation. How do you go about giving a presentation? What does that mean? Secondly, how do you go about doing it with technology, right? Recording it. And so if you're recording something like, you see me recording things, you need to think about your presentation. You need to think about the background of the recording. If it's a vidcast, you need to think about what visuals you want to show and audio, and you can, there's a lot of ways you can make it interesting and to get the audience's attention. Okay, that's important. And I just want to encourage you to think about that. And I want to encourage you to think about doing it more creatively rather than just say, for example, doing a document as such.
Michael, I got one question. Could be silly question.
No silly questions, Usman. No, they don't exist. Sorry. All questions are good questions.
When we have to do the presentation, do we have to? It's for the question number 1.
Yeah.
You have to mention all the acts and any like a section or cases into that as well.
Well, don't forget it's a law assignment, okay? And you're present. Okay, so there's a couple of comments I'd make on that. Good question, by the way. Very good question. It's a presentation to the partners of the firm, so we keep our focus on that, right? So we know these people are senior professionals. Put it like that, right? And they're our bosses, in quotes, right? But as was pointed out earlier, it is absolutely the case that you cannot assume that they know what the legal environment of this subject matter, because they may not deal with property law at all. They might deal with taxation law. They might deal with it, and of course they're coming because they might be interested in terms of how this could be useful for them and with their clients. You know, remember the business focus again, right? So it's getting that balance right. You certainly need some law there. Yes, you need some legal material there. But this question is different to the other problem-solving questions in that it's not just about presenting the law, okay? It's explaining the points you want to make about these mechanisms in a way that's interesting, has some reference back to the relevant legal environment or the legal context, which is important in anything we do in law, right? But is also engaging with the audience that makes it interesting. Not only interesting, but is, don't forget partners, if we could put ourselves hypothetically into this scenario, right? Partners' time is valuable. They won't, I know I'm hypothesising a bit here, but they won't appreciate their time being wasted.
Especially the ones that bill by the minute, right?
Or even the ones that bill by the second. And don't forget, they especially won't be impressed by one of their solicitors wasting their time.
They're wasting their money too, yeah.
That's right. So this is an opportunity for you, not just to, you've got to get the balance right here. This is what I want to say. So it's not just about grandstanding and saying, oh, look, I know all there is to know about this area of the law. Well, they're not really interested in that either, right? What they want to know is they want the critical bits. They want it to be interesting and it's been an interesting presentation and it was worth me coming along. But where's the catch? Where's the catch in terms of why this is going to be helpful and useful for me in what I do with my clients? The business catch that I was talking about before? So you can think about that dimension of your presentation. Right? And you might say to me, oh, but Michael, how can I can't possibly capture all the departments of law and so forth that might be in the firm. I know that. Of course you can't do that within the parameters of the exercise. But is there something in your presentation that is reflecting that you have that awareness? I'm going to be looking for that.
So you're asking for where does land law in your presentation touchstone with other areas of law in regards to other members within the firm. So not all members in the firm, but some members in the firm will have touchstones that connect with land law.
So again, just as an aspect of what you're doing, right? And when we start to think about the exercise in those terms, it opens up other possibilities as well. Because now we're starting to think about, well, okay, how does property law / land law connect with other areas of law practice, other law problems, law puzzles? How does technology, as we are understanding it and coming to terms with it in terms of its impact on property / land law, how is that relevant for other areas of professionals in the firm to be aware of as well. Yeah.
Got one more question, sir. When we have to do this assignment in a group, I'm not really sure whether I think I read somewhere, is it has to be like a 4 person in the group?
No,
or like
no, up to 4, Usman, up to.
Up to 4, okay. So 3
So
people.
obviously a group can't be a group of 1, right?
Yeah.
So the group can be from 2 members to 4 members. And if you do it as a group, and I want to encourage people to think about doing things in groups, but it's fine if you can't, right? But I want to encourage you to think about doing things in groups. And if you do it as a group, then I need a verification statement about your individual involvement in the group assignment, okay?
And so when we have to do the video, so in doing so in a group, do we just make a one video suggest presenting, or we just all have to make like I can't understand how, I mean, we're gonna do like, let's say,
What are we doing at the moment, Usman?
So we just do the same way, so we just present to each other here.
Well, that's up to your group members to decide the dynamics of it. But the Zoom technology allows you to have group members in different locations doing exactly like what we're doing, and you can do a presentation just exactly the same way I'm running a class.
Okay.
Huh? So that technology allows you to do that. It also allows you, like you've seen what I do, I screen share things and so on, right? If you can set that up, there's no problem with doing that. And the Zoom technology is not only through a computer, you can also have it on your mobile device. Now, I'm not suggesting that you do an assignment on a mobile device, but it is possible to join via the mobile device, right? So it's a great video conferencing technology, which you see we use all the time, but you can use that yourself. You can use that working with other students. And I'm giving you the opportunity to do that. And that technology, which is at your disposal, it's freely accessible in the way that you're using it. Yeah, I think that's a great form of technology to share with and team up with others that aren't necessarily in the same location. And then you can talk about how you're going to structure that presentation.
With verification of ID, so we just like, if you can just tell a little bit more, do we have to give you any sort of paper or any photo ID in there?
No, it's not necessary to have a paper document. So that, for example, in a recording, right, I can see you on screen now, and I can see your name on screen. Okay. Now you can also somehow include, if you want to, I mean, your student ID, if that's what you want to do as well. And then you can just have a brief statement about your, what is your involvement in this group exercise, right? And to capture it as an audio like that, or even as a, you could even do a PowerPoint slide showing, that. But then I can see you there. It's not just a slide, right? That I just need that as a verification of your involvement. It's not full land title practice manual compliant, but it's something that we're increasingly asking for, just to ensure that in group work, which I think has benefits. I know it has challenges too, folks, but it has benefits. But that those that are in the group are all involved and participating in the process. That's what it's about.
So no green screening or deep faking, Michael, is that what
This is, I don't know, Nicholas, this is it's going to be an issue going forward, isn't it, really? But we can only do our best. And that's a part of ensuring that in group situations, everyone's involved and participating in that as is intended. Doesn't always work, as we know sometimes, but that's the purpose. And also that this is your work. That's really important because it's an assessment task, right? Yes, we have challenges, in education, just like in every other environment with technology, but we do our best to achieve best practice outcomes. Anything else, folks?
Can I just ask one more question? You might not even be able to tell me.
Can I ask another question, Shana? I'm looking forward to your questions.
So with the caveats,
Yes.
it's basically just like something that stops other interests from being registered until the dispute is settled, right?
I have to say that's subject to your interpretation.
Damn it.
So, look, I mean, part of the exercise is to, explain the nature of the mechanisms that you're being asked to talk about.
Is that back to Rule 4? General law, Rule 4, if it's probable.
That's right. I don't know about that. The other thing is that don't forget, again, this is a presentation, so you want to keep the partners interested. So practical examples can be useful to keep people interested, okay? Not just descriptive.
About question 2, sorry.
Sorry?
I was talking about question 2, sorry, I should have clarified that.
Question, okay. So, okay, now, all right. So, sorry, okay, so go back and recast your question. Sorry, this is about problem question 2. Yes, sorry, go on. Go back.
Sorry, I'm just trying to understand caveats so that I can answer that question, obviously. And what I get from it is a caveat is something that if a dispute arises between two unregistered interests, you put a caveat, someone puts a caveat there so that the other person can't register their interest until it's decided who has the the first interest, you know what I'm trying to say?
I do, but I have to say back to you, Shana, I have to say that's subject to your interpretation, because that's a part of what the assessment is testing.
Okay.
But it's important to work out what this mechanism is and how it works. And don't forget that you don't only have to rely on your casebook and the materials for that, but these mechanisms, because it's part of the Torrens framework and the land title framework, you can go to the website for the Department of Natural Resources and Mines in Victoria, where you will find a hyperlink to the land titles section, and there will be explanations there that might help to further your understanding. And of course, the Land Title Practice Manual may also have practical guidance and information about this mechanism. So you can look at other sources that might be helpful to get to clarify your understanding about this before you need to apply it in the context of the problem question in question 2.
Okay, thank you.
All right. Anything further, folks? Are we all good?
Yeah, since we're all here,
speaking
about question 1, we obviously can't submit like what we've just done, right? Because we've just all been in a group and basically did a screencast and recorded it anyway.
Yes, you can't do what you just done. No, that's right. Yeah, look, there's a technical point. I got a student ask me about this. So if you do a recording, all you need to do is to give me the link. All right? That's all you need to do. Just give me the link. So the process is, if you choose to do a recording through Zoom, right? There's other software you can use, but if you choose to use Zoom, you can then upload the recording into YouTube. The uploading of the recording into YouTube, once it's gone through a process and you publish it, it will then give you a URL. That's all you need to give me is the URL.
Well, you can leave it unpublished too on YouTube, and as long as you have the link, you can access.
Yeah, of course. And you can make choices. If you haven't done this before, you can make choices about well, you've got to publish it, but you can publish it so that it's private or public or restricted. You can do various things, but I've got to have access to it. Right? You can't give me something that I can't get access to. Okay. So, what I wanted to say to you is, because, for those of you maybe who haven't done recordings before, one of the challenges often is the file size of a vidcast. Audio podcasts aren't a problem because the file size is quite small. It's only the audio. What chews up the file size is the visual. Okay. So uploading the entire file can often, it can take, depending on your internet connection and so forth, that can be sometimes a problem. But what I'm saying is, in your assignment, you don't have to upload the recording. All you've got to do is give me the link to where I can find it, and I can click on the link, and there it is, YouTube link or whatever you're using. Okay, but you need to test it before you do that to make sure that it's accessible and that it is the recording that you want me to see. Okay.
Michael, I just put a link up there. You can check it if you like. If you find it of value, you can share it with others. It's about creating a YouTube account and how to use it properly.
Yeah, no, that's good. People can see that are there. And what I will do is this recording, when it gets uploaded onto Moodle, I will also upload well, it's not a very extensive chat box tonight, but that site, Nicholas has put that site there, which is good. So, and look, I just encourage you, if you haven't done things with multimedia before and so forth. I know that's sometimes a bit scary, right? Green fields, new things, but be encouraged. Be encouraged to try new things. Be encouraged to experiment with the technology, because it is part of the environment that professionals operate within today. Okay, that's just how it is. We're doing it here in our context of education, and the reality is, folks, you're not aware of this, but we are actually at the cutting edge of use of that in education because of how we do things and that. But as lawyers going forward, you need to absolutely be conscious of how these mechanisms of technology are going to be a part and parcel of your professional lives and professional environment. So
I've got one more question, Michael.
Right, this will be the last question, Osman. Last question.
Yes. Sorry for that. It says 10 minutes, we have to do this presentation. So let's say like we are 3 people, so 10 minutes for all these 3 people. And as you said before, it's gonna be like what we're doing right now here. We're doing here right now what I believe is more like a discussion, once we do the presentation, is it gonna be like that? Okay, one person start and then finish, and then next person start, and
you have to decide that, Usman.
It's up to us.
These are management issues that, as part of doing things in a group, you have to decide how are you going to do it, who's going to do what roles are you going to play, but there's got to be something where it's clear to me that you're all involved. Okay, that's important as part of the verification process, but that's something that you can talk about and discuss and decide. Okay, and if there are, just going back, I think to Shana's point earlier, 10 minutes, you might say, oh, that's a long time, but as soon as you get a few people involved, it's not very long. Okay, if you all say there's 3 people, 10 minutes, you've got 3 minutes each, that's not very long. Okay. Just depends on how you decide to work things out. If it's one person doing everything in 10 minutes, well, yes, that's maybe, I don't know, a bit takes a little while, but you'd be surprised when you do something with multimedia, how quickly the time just goes. Okay. When I do my lectures, for example, I know sometimes my lecture's probably maybe a little bit too long. I don't know. Sometimes I decide to break them up because I don't want to make them overly long. It's hard to get the balance right sometimes between the amount of material that I would like to present to you in various ways, but understanding how long you're going to sit watching or listening to a recording. And the other thing is I have analytics where I can look at what people are watching and how long they're watching and so on, you know. And so that's also something that once you get into this sort of stuff, you can learn more about that. Nicholas, I'll give you one last question, and then we'll.
Well, it's not a question; it's more of a comment. I was just going to react to what you just said and say that, I mean, most of the screencast recordings I do for tutorials and videos that I make are only 5 to 10 minutes long, and because they're on YouTube, I get all my analytics too. So there is value in that, in knowing.
Yeah, and look, another thing too is, and I'll finish on this. When you see something and it says, okay, well, the average viewing time is say 20 minutes, and you've made a recording of say 40 to 45 minutes, it doesn't mean that they haven't looked at it all, because as you know, you can speed through things, because you can watch it off real time in a way that you can't in real time. So you can't actually speed me up when it's in real time, but you can certainly jump around and do things with a recording.
Yeah, you can put a recording on 1.5 speed, and so it goes at 1.5 times the speech pattern of the original orator. Yeah,
that's right. And you can actually use the cursor to jump through and see the various bits that you want to look at if you're able to do that and make those choices. All of these things are possible with technology today, including the fabrication of identity. This is also possible today. And so that's another frontier challenge for all of us in various ways. So.
That's the deep fake challenge, Michael, to have Nicolas Cage appear in every movie made on the planet. Haven't you seen that? The website is there for it.
That is the deep fake challenge, Nicholas. And it's a challenge which is before us, and somehow we've got to respond to that.
It's one that's scaring a lot of people, I know that.
Well, it is understandable. And the other thing we will finish on this because I've got to get on and do stuff, but the other thing that is worrying is the increasing prevalence of digital and optic recording of facial recognition, and how that's being used, and how it's been increasingly used in public environments, not only public environments but in other environments, and yet the technology isn't as developed as it could be, and so there's a lot of concern around the accuracy of the technology.
A lot of mistakes being made with it at the moment. Is there a plausible point?
Yeah, that's exactly right. And then when you leverage in to that, these developments around, what we've referred to as things like deep faking and so forth, and when these coalesce together, we're in a brave new world in many ways. And what can we do? We just have to go with it step by step, and we have to be aware of these developments. Can't close our eyes to them, but at the same time, we have to continue on our course of what we believe is what's important and what's necessary. And we can't do anything else than that, I don't think. Anyway, we'll call it a night there, folks. Hope that's been useful and helpful in providing some further information and clarification. I do appreciate that when, sometimes I require my students to do more interesting, I think more interesting things. Sometimes they think, what is this really about? What's possible, and so on. So I'm always happy to give clarification to help you to better understand the nature of what I'm seeking, and also to allow you to be encouraged to do things more interesting things, and more engaging things in various ways in thinking about the law and its communication. So it's good night from me, and it's good night from him. Good night.